Hello friends, in the YouTube channel Advocate Amit Kumar Gupta. Today we will discuss a very important case on section 148 which has been decided in a writ petition filed by the Assessee in the Allahabad High Court. The name of the case is SANTOSH, KRISHNA, HUF versus Union of India and others, and the case has been reported in 449 ITR at page number 457. The date of the judgment is 18th April 2022. In this case, a notice under section 148 was issued to the assessee for the assessment year 13-14. The date on the notice was 31st March 2021. The notice was issued to the assessee through email and from the ITBA portal, and according to the affidavit filed by the department in the High Court, the date of the delivery of the notice through email to the assessee was 1st April 2021 and the time was in the morning, near about 8 a.m. The assessment under section 147 read with the section 148 was completed. Wide order dated 31st March 2022. The assessee raised a point before the learned assessing officer before the National Faceless Assessment Center that this notice is time barred because it has been received by the assessee after 31st March 2021. But somehow the assessment was completed without taking this plea of the assessee. So after completing the assessment, the assessee went to the Allahabad High Court, and Allahabad High Court, after examining all the facts and circumstances of the case and after taking into account the affidavit filed by the department that the mail has been received by the assessee according to the information received from the ITBA portal, that the notice has been delivered to the assessee after the limitation period, that is 1st April 2021 in the morning. The court quashed the notice and consequently all the assessment proceedings. When the time was there, when the notices were served through post, there was also a lot of litigation on the point of the service of the notice. When this system came of issuing the notices through the portal or through the email ID, then this type of controversy is going on. Earlier also there were a lot of technical issues, and now also in the regime of this digital era, more issues are coming which are related to the delivery of the notice. So whenever we are following our assessment, we should examine very thoroughly that what is the date of the receipt of the notice, what is the time of the digital signature. Sometimes it may happen that the date of the notice is different and the time of putting the signature and the date is earlier to the date of the notice. In some cases it has been seen that the approval have been obtained earlier before the date of the notice, or you can say that in those cases there were the instances that when the notice was issued, the approval came thereafter. So when the assessee applied or requested the copy of the approval from the department, the assessee came to know in those cases that notice was issued first and then approval was taken. So in those cases also the courts quashed the assessment proceedings. So these technical points are very important because it may happen that in some cases we may be a little bit weak on our merits. So we should side by side take our technical grounds. It is our legal right that we can take this, because department also take the technical grounds against the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is SANTOSH KRISHNA HUF versus Union of India and others. And this case has been reported in 449 ITR at page number 457. Thank you, friends.